Hello, my name's Roman Kubiak and I'm a partner and head of the Private Wealth Disputes team here at Hugh James, and I'm joined today by Ryan Taylor, also in the team. Hi Ryan.
Hi Roman.
So today we're looking at the potentially complex, thorny issue of cross-border estate and trust disputes, and kind of the problems that arise, and obviously things you can do to help with those. So looking, I guess, first at the issue of just generally, you've got a deceased person and they've got assets here and abroad. Obviously, you have to take into account all these considerations. The starting point is to look at their domicile, isn't it, usually?
It is.
And when we're talking about domicile, there seems to be, people think, oh, right, domicile, that's your nationality, or that's where you lived when you died. It's not as simple as that, though,
It's not
is
the
it?
same thing, no. So starting point is everyone's born with a domicile of origin.
Yep.
Problematically, perhaps, starts with the domicile of your father. So it's not always where you're born immediately. It really depends on a number of factors. But generally, we'll say domicile of origin may be where you and your father are based.
That's it. It's effectively inherited from your father, unless your parents weren't
Exactly.
married and then you inherit it from your mother.
Exactly. And so that once you've set up that domicile of origin, that stays with you for life. It's a sticky origin.
Yeah.
But you can change that domicile over time depending on your choices about where you look to live. Again, distinct from residence, because that may be a temporary thing. Domicile of choice needs to be a permanent decision on where you're going to live.
Live out the rest of your days, really, isn't it?
Exactly.
Yep.
So a permanent move to a new location may be enough to change that domicile to your domicile of choice. Sometimes people move again, even though their intention was to remain there permanently. And so at the point where you may move, it then reverts to your domicile of origin until you make a new domicile of choice.
And the reason this is important for issues with cross-border estates is your domicile, certainly for the purpose of England and Wales, will dictate the law which applies to the distribution or devolution of your estate and to any claims that you can bring in which courts have jurisdiction.
Exactly.
So, for instance, we've spoken before about claims under the Inheritance Act, and there one of the qualifying factors is the deceased must have died domiciled in England and Wales. And this is important generally because the laws which can apply to how your estate is distributed on death vary between different jurisdictions. So in England and Wales, we have what's called a common law jurisdiction, and under a common law jurisdiction, we have freedom of testamentary disposition. Basically, you have the freedom to give out our estate as we see fit, subject to certain checks and balances. Whereas in many parts of Europe, for instance, and in some states in the US and so on, you've got civil law jurisdictions.
Yep.
And civil law jurisdiction is different. They predominantly tend to look at forced heirship.
Exactly.
So the law there specifically says that regardless of whether you've got a will or not, you have to provide certain set proportions of your estate to certain people.
Yeah, so maybe provision for spouse or children,
Right.
and again, varies by jurisdiction, but it may say perhaps a quarter or up to a third of your estate is for you to distribute how you like we have in the common law jurisdiction, where you can pick and choose under a will, but then a certain percentage may be protected and subject to that fettering by the forced heirship rules to protect and make sure that people in the immediate family are always provided for, regardless of what you want to do with your free proportion.
And even if you have someone who is domiciled in England and Wales, that doesn't mean that the law of England and Wales will apply to the whole estate. So, because there you've got two principles. You've got the law which governs what are called your movable assets, so let's say liquid cash and a car or artwork, things like that, and then the law which governs your immovable assets, so real estate, property, things that are fixed to the ground, and that's different. So what the law of England and Wales says is that the devolution of your estate of immovable assets, so the fixed assets, is governed by the law in which that asset sits, effectively. So what's called lex situs, exactly. There we go. We managed to get a bit of Latin in.
There you go.
So it's your lex situs. So what that means is effectively that if, say, I own my Tuscan villa, then and I've got assets here as well. When I die, I make a will here. I've disregarded making a will in Italy, but let's say I make a will here. That will deal with my immovable and movable assets in England and Wales. It will also can potentially extend to my movable assets in Italy. So if I have an Italian bank account, they can deal with those. But the property will be dealt with under Italian law. Now, it can get a bit more tricky because you then look at what does Italian law say? Are there forced heirship rules there, or will it refer back to the law of England and Wales? And with something, it's called renvoi. So what that means is that the law of England and Wales will apply Italian law in respect of how the property is devolved. But then if, say, Italian or any other civil law jurisdiction or any other jurisdiction has a provision which then kicks it back to England and Wales, you then almost have a ping-pong situation. And that can cause practitioners a lot of headaches, and certainly individuals and beneficiaries.
It can. I mean, the interplay between different jurisdictions is always something that you need an expert to look at to make sure that you're dealing with either the movable or immovable parts of the estate properly and applying the correct jurisdictions. There's also EU regulations that have been brought in to try and govern the renvoi aspects, where they're trying to make sure that there's a more codified across the European Union way to deal with when foreign law may apply and when it doesn't. It doesn't change the inheritance rules in each of those jurisdictions, but it does look at a little bit more detail on when we should refer back to other jurisdictions.
Yeah, I mean, its purpose, the EU succession regulation, I think it's 6050/2012 or something. I don't know how I pulled that out, but it's known as Brussels 4 for short. But effectively, that looks to bring cohesion to the member states of the EU, well, to most of them, for those who opted into the regulation. But it's still, even though the UK didn't opt into the regulation, and B, obviously post-Brexit, we're no longer a member of the EU for these purposes, it can still apply if you've got assets in those jurisdictions. Because what you can do is, what it says is that the law in which, and this is where it gets different and where potentially complications can arise, is we use the concept of domicile. In the EU under this regulation, they use the concept of habitual residence.
Exactly.
And you can either, so what it says is that the law which governs how your assets within an EU state are devolved will be determined by your habitual residence, or you can elect your nationality. But you need to do that. It needs to be a valid election under a will or a testamentary document to be able to do that. And like I said, the purpose of that is to bring cohesion within that. That being said, France have issued a civil code, and there was a case in Germany recently, both of which effectively said, well, that's very nice, but actually we're still going to apply our own forced heirship rules. So, as much as they wanted cohesion, it now looks like a number of these EU countries are looking to move away.
Bringing in their own exceptions to it.
Exactly. So that's the first thing is to establish where was this person domiciled? Certainly when we're looking at claims, because that will govern both what happens to their assets and also whether it's right to bring claims within the forum of England and Wales. And we've had a number of examples of this. So I remember I acted for a client whose spouse had passed away and had cash assets in Jersey, property in Switzerland, Austria and France, and a property and assets in England and Wales. And when they died, the executors had declared her domicile as being in Switzerland. Now, Switzerland has a number of different what are called cantons, but that's effectively irrelevant for these purposes, because what that potentially did, and the will cut out the husband, it potentially precluded him from bringing a claim within England and Wales for financial provision under the Inheritance Act. And it potentially also scuppered chances to bring will dispute here. But we were able to successfully show that actually her domicile was in England and Wales. She'd lived here, so she was born here. Her father was born here, so she had a domicile of origin here. And we were able to show that a domicile of choice wasn't in Switzerland because she was only there for work. They lived a very peripatetic lifestyle, moved around a lot. And there we brought these claims. We were eventually able to agree a deal which provided for husband, meant various transfers of assets within the jurisdictions, but we then had to get those certified and approved in the various jurisdictions. And particularly in Switzerland, so there that needed an application approval because there were minor children involved by what's called the Justice of the Peace. And I mean, that's just one example of where obviously that comes into play, but the key point is where there are these assets abroad, it's knowing knowing the different laws that apply, but also working with legal teams
Yeah.
in those different
So
jurisdictions.
you're looking for some synergy between having the expertise advice here in England and Wales to look at the assets here, but also how they interact with the local legal team to make sure that they're getting the appropriate advice in that jurisdiction.
Exactly, and I mean, we've just done it. We've just completed it on a case in Brazil, and working with the Brazilian legal team to make sure that those interactions work well. Because, frankly, we are experts at the law of England and Wales and how that interacts with offshore jurisdictions. But what we're not going to do is to be a jack of all trades, because no one is, and it's working with those right people as well. And I mean, as I say, in terms of that, provided you've got these qualifying, domicile or succession rules, then you can bring these claims and you can bring assets in. I mean, that's in the context of estate disputes, but an area which we look at a lot is cross-border trust disputes.
Yeah.
Like, for instance, in the Channel Islands or across Europe and further afield, the Cayman Islands, BVI. Bermuda, these are big trust jurisdictions, and I guess people have historically seen the word trust. It's a bit of a dirty word, they say, but actually trusts are really useful tools.
Yeah, they're a great estate planning mechanism for a lot of people, or even during their lifetime looking at minimising and tax or protecting assets from other family members or perhaps business interests.
Or for family members, for intergenerational wealth and
exactly.
passing that
down. They're a great planning mechanism and can perform a really useful function, but there's complexity in when we offshore those assets and put them into the hands of a trustee that may make a dispute more complex later on. And so we need to look at how we engage with, again, legal advisors in those jurisdictions, but we certainly know what we're doing. And
well, that's it. And I think what tends to crop up, because we obviously react for a lot of individuals challenging trustee decisions, and likewise we act for a lot of professional trustees, and there tend to be a number of common themes that arise, and normally they're within the context of discretionary trusts. So this is where trustees have a discretion within the confines of the trust deed and any potentially letter of wishes. They have a discretion on how to apply capital or income to beneficiaries, and you invariably get beneficiaries who are disgruntled or unhappy about this, and the rules which apply depend on the specific trust jurisdiction. But for instance, if we take the big ones, if you take Jersey, Guernsey, Isle of Man, Cayman Islands, they all broadly speaking derive from the common law jurisdiction. So we have our Trustee Act, they have their Trustee Acts. There are some key notable differences, but they're similar in many ways. And in terms of the cases, in case they go to Privy Council, these tend to be applied across these jurisdictions, and certainly our case that goes to the Supreme Court have persuasive authority, aren't always necessarily applied, and if they're not, or if they are, then often they're codified, for instance, in the Jersey Trustee Act or so on. So the big issues that tend to arise then are challenging trustee decisions. They'd say, well, you haven't exercised your discretion in my favour or to my benefit, and the way you can often start by doing that is by making disclosure requests. And whether or not trustees can and should provide disclosure, very case specific, isn't it?
So one of the presumed disclosure categories would be on accounts. So there's a general rule that beneficiaries are entitled to see the accounts, figure out what assets, what's being earned, what there may be in terms of availability for distribution, but the decision-making process that's happening behind the scenes may not be fully disclosable. Really depends, again, as you say, on the circumstances of each trust. But that doesn't stop the courts having the ability to look at the decision-making process and try and decide whether trustees are making appropriate decision in those cases, whether it's taking into account all relevant factors.
That's right. So it's, for instance, they'll look at whether trustees have taken account of all relevant considerations and, discounted all irrelevant considerations. And one of the big cases was a case called Schmidt and Rosewood, which looked at disclosure, and really what seems to say was to move away from this proprietary right that they said that beneficiaries had an entitlement to disclosure, to looking at the specific facts of the case, looking at, well, what rights, what entitlement does the beneficiary have under the trust? Is it a very remote right, in which case you're less likely to order swathes of disclosure, or is their right more immediate,
Yeah.
in which case you're more likely to get disclosure.
Pragmatic approach.
Yeah, exactly. And then that's often that once you've got that disclosure, you then look at whether there's anything within there that can assist with either challenging a decision, or from the trustee's perspective can assist in protecting them from a claims, for breach of trust, for instance,
Yeah.
or challenging that. You then have alternative claims, for instance, where you want to set aside a transaction for mistake. They don't necessarily need to be hostile claims, but they're claims we advise trustees on, and generally where they arise is where trustees have perhaps made an appointment out of a trust or entered in some transaction which had unintended tax consequences.
Sure.
And this was originally known as the Hastings-Bass Rule from the eponymous case from the 1970s, but then the Supreme Court had joint decisions of Pitt and Holt and Footer, which effectively then changed the parameters of when the court can set aside transactions for mistake.
In England and Wales, though.
In England and Wales. And
offshore hasn't always necessarily followed that.
Exactly,
change.
that's right, yeah, because I think, offshore, in a number of jurisdictions, they decided not to follow that. Because they didn't like how
fettering.
How fettering, yeah. Or futtering, if we're going to use the case name. That's a dreadful pun, sorry. But the point is, that you've got these transactions. They can be set aside in the right circumstances and to undo and unpick any unintended tax consequences, for instance. A big thing that I'm seeing in the offshore trust world now is blessing applications.
Yeah.
So
looking at getting a decision approved.
Yeah. And we're working on one at the moment.
We are.
So, with these blessing applications, effectively, as you say, it's asking the court to effectively sanction a momentous decision. So it might be within your trustee's powers to do it, but it's so momentous, so large, that such an important decision, you want, as a trustee, the safety of a court order, the comfort blanket of the court order.
It's not the kind of application that you would make on every decision that a trustee can make, because the courts are not really going to entertain that. They need to be kind of very unique circumstances where the trustees need that approval to protect themselves and the trust from perhaps dispute by a beneficiary.
Yeah, and an example might be, for instance, selling a family company or selling a shareholding family company or a home, for instance. And they're also known as public trustee and Cooper applications from the eponymous case. There's a lot of eponymous cases here that arise in the trust world, but those are generally the big ones. But then also you have issues around trustee removal, and again, I mean, they're depending on where the trustee is located. And here you're not looking at the domicile of the person who created the trust. What you're looking at in a trust context, as to which law applies in which jurisdiction, is the proper law of the trust. So, and that's, usually you'd have that within the trust deed. Now,
very express.
Yeah, exactly. And you'd hope it is, but if it isn't, then you'd look at a number of factors. You look at where the assets are located, where the trustees are located, where the settlor, which is the person who established the trust, where they're located. You look at all these factors again, and on a case-by-case basis, establish, what's the proper law of this trust, and therefore which jurisdiction do we need to bring any potential challenge or defend any challenge. So whether that's in England and Wales, whether it's the Channel Islands, wherever it might be. And that's crucial again, because then it determines what remedies might be available. So, if you are looking to remove a trustee, for instance, you're doing that applying Anglo-Welsh common law principles or principles elsewhere. And that applies not just to trustees, but protectors. Protectors are a big thing, particularly in the offshore trust world.
Increasingly.
Yeah, and as the name suggests, they're there to kind of act as the guardians, to, I guess, keep checks and tabs on trustees and the exercise of their decisions.
Yeah, and I mean, they're useful because, trusts can last for a very long time, and so after the settlor may have gone, the protector can kind of step in to look at, perhaps, do we need to remove a trustee? They're given very specific functions set out in the trust document as to what they can do, where they need to approve certain transactions, perhaps certain payments of capital rather than just income. Those kinds of functions can be tied into the role of the protector, overseeing the duties of the trustee. Yeah,
exactly that. And again, if there are concerns about the way the protector is using their powers, if they're either overstepping their mark or perhaps not actually doing anything, then again you can make applications to remove them. I think the key point in all of this is you need to have a clear understanding about the various rules, about the conflicts of laws, because that's a huge issue, is the conflict of laws, whether, the law of England, Wales may accept jurisdiction, but another jurisdictions, courts may say, well, actually, no, this is something, we're dealing with. I mean, another example of a case we dealt with, a reported decision, was Rokan, where you had clients' parents, they were Norwegian, and on father's death, mother had entered into effectively a contract to leave the her inheritance to her children, equal shares. Came over to England, Wales, they made a will which basically effectively circumvented that, overrode that, and the court said she was perfectly entitled to do that because she'd acquired a domicile of choice here. Law of England and Wales applied. It wasn't a binding contract in Norway, and so it overrode that, which, I mean, some would say was a surprising decision, but the point is it just shows the need to understand how these various factors work. And I was going to make another point, but I've forgotten what it was.
Okay.
So I need to gather my thoughts, and it wasn't domicile, it wasn't right.
Coming on from Rokan.
It was wills. Oh yes, okay. So an issue which clients we see who have been poorly advised, or deceased have been poorly advised on, is about the impact of making a will or settling a trust and not considering the impact of the foreign jurisdiction. So a classic one is someone has assets has a holiday home in Spain or has cash in Spain as well. They have assets here, and they do everything great. They make a will in Spain, which deals with their Spanish assets. They come over back to the UK, decide to make a will here, and they haven't checked it over properly, or have had poor advice, and the will says, I revoke all former wills and testamentary dispositions. Now, effectively, what that means is that then automatically revokes the Spanish will, and then they've got forced heirship applying to their estate there.
So specialist legal advice is always advisable. We do see those cases come across our tables sometimes where someone thinks that they're doing the best for their family by getting the advice in the appropriate jurisdictions, and that's great, but it's important that those people also understand the impact of what they're doing in each jurisdiction on other jurisdictions, for exactly the reasons you say.
And there are remedies potentially you can look at. You can look at, whether you rectify the will to remove that clause, for instance. You look at whether were there any concerns about the seed, or if you can't do that, then potentially there's professional negligence claims against the advisors.
So we can certainly jump in to assist and try and overcome these burdens where they have arisen, but best advice sooner is always the recommendation.
Prevention's better than the cure, isn't it?
Exactly.
So make sure your wills are properly drafted and prepared, and you've got specialist legal advice. Thank you very much, Ryan.
Thank you, Rowan.
Cheers. Might need to kind of move bits around because you kind of went estates, trusts, wills, so maybe estates, wills.
The good thing about this software we use, it actually draws a script, and you amend the script and amends the video.
Yeah,
bloody hell.
that's very good.
That's insane.
You can actually make it, when you said about stage 4 or whatever, you can actually rewrite it, and it will try and get you to try and use your language, your voice.
What?
Yeah, it's crazy. When you talk about the crypto,
So that's
that
full
fraud thing, it's exactly what it does. Yeah.
That's a deep fake. Oh, I could have sounded much smarter. I should have just said random crap for
You
me.
can have your leave.
Was the thing I said about protector's right? Because I kind of shut off half.
It was good. Yeah, it was good, mate.
Fine.
Really good.
All right, Grand. Thank you. Should I wait in here and do Kieran, because then you'll continue with him?